Okay, welcome everybody to tonight's webinar. Tonight our topic is Powers of Attorney, Understanding Your Legal Rights and Responsibilities and Common Issues. So I'm very pleased to have four lawyers with us this year from Siskinds. So we have Leanne Kuchynski, John Morrissey, Cloe Gonyou, and Mariana Peres Toledo. So welcome to all of you, and I will turn it over to you in a second. For those of you who are attending tonight, there will be a question and answer portion at the end of the presentation. So you are welcome to enter your questions in the Q&A at the bottom of your screen. So if you move your mouse or touch your screen at the bottom, you'll see a little Q&A with a question mark. And if you click on that, you can type your questions in there. And then Sonia and I will read those out at the end of the presentation to the speakers. The chat function doesn't work, so don't put anything in the chat, but it's the Q&A that you want to enter any questions into. Okay, and with that, I will turn it over to you guys.
Great, thank you, Tara. Good evening, everyone. Thank you for attending our presentation tonight on Power of Attorney, Understanding Your Legal Rights and Responsibilities and Common Issues. Today we'll be discussing a variety of topics pertaining to powers of attorneys. Our goal today is to provide you all with the background information regarding powers of attorneys so that if and when the time comes where you may need to use power of attorney, you will have the knowledge regarding what that is and also what is required of this role so that when the time comes, this process can be as seamless as possible. John, Mariana, and Chloe and I are part of the Siskinds Estates team, and we are very happy to be here. I would like to especially thank McCormick Care Group for having us here today and providing us with this opportunity to speak about this very important topic. So briefly, my name is Leanne Kuchynski, and I'm associate at Siskinds. I am a lifelong Londoner. I am also part of the McCormick Foundation, and I practice in estate litigation, and in particular, I deal with disputes concerning the validity and interpretation of wills and powers of attorneys, disputes concerning when that document comes into effect and actions taken by powers of attorneys or estate trustees in their role and dealing with estate accounting as well. Thank you again for having us, and I will take this to Chloe.
Hi, everyone. My name's Chloe. I'm an associate at Siskinds. I've been practicing for a little over a year now, so I'm considered a baby lawyer. I practice estate litigation alongside John and Leanne, as well as general litigation, which involves property disputes, contract disputes, and neighbor disputes.
Good evening, everyone. My name is John Morrissey. I'm a partner at Siskinds. I'm in my 10th year of practice. I practice primarily in the area of estate litigation, capacity litigation, power of attorney disputes, basically everything that Leanne just went over. I am the father to two beautiful daughters. I'm on the board of directors with the Alzheimer's Society Southwest Foundation. And before I became a lawyer, I worked at a local funeral home, which served as a nice transition into my estate litigation practice.
Good evening, everyone. My name is Mariana Peres Toledo. I'm an associate lawyer with Siskinds. I practice in the Wills and Estate Department, so I'm responsible for drafting the wills, powers of attorney, and also for estate administration. And I have been a lawyer for 5 years now.
So I'm just going to provide an overview of the topics that we will be addressing today during our presentation. So first, Mariana is going to discuss what are powers of attorney documents and explain the two different kinds of powers of attorney documents that can be completed. Then she's going to discuss the considerations that should be made in determining who should you choose as your power of attorney. And then Chloe is going to discuss how you implement those wishes in and actually how to make a power of attorney document. Chloe is then going to provide an overview of how the power of attorney comes into effect, as well as when a power of attorney is no longer in effect, and those are two very important topics. I will then discuss the importance of making powers of attorney documents, and then John's going to outline the consequences when you don't have those documents in place. And then I'm going to discuss duties and responsibilities of a powers of attorney. And then John's going to outline the duty to account, which is one of the major responsibilities required of an attorney for property. And then we're going to discuss some red flags that we commonly see and then common issues that we see through our practice that particularly pertain to actions taken by powers of attorneys and just outline what to avoid and also how to look to what to avoid. And then Chloe's going to outline some law examples just to provide an overview of real life examples of what happened and how to avoid that in the future. And then Mariana will provide an overview of estate planning and how this intersects with powers of attorney documents. And then again, at the end of our presentation, we'll have plenty of time to go over any questions that you may have.
So, what are powers of attorneys? They are legal documents that a person can choose to create that set out who will make decisions for them if and when they become incapable of making the decisions themselves. The grantor is the person who makes the power of attorney document, and it's known as the grantor because it's the person that it's granting a power of attorney to someone who is then named the attorney, right? Who will be the attorney for that person. It's not a requirement to make a power of attorney. However, if you do not grant powers of attorney and you ever become incapable, you and your loved ones will find yourselves in a legal dilemma. And we'll explain more about this throughout this presentation, but it can create some challenges, right? There are essentially two types of powers of attorney. There is a power of attorney for property and a power of attorney for personal care. A power of attorney for property, a person will be assisting the grantor to manage their finances, their properties, and the power of attorney for personal care, the attorney will be assisting the person in making decisions with respect to healthcare, nutrition, dwelling, and etc. The attorneys for property and for personal care, they're broadly known as substitute decision makers. And so the Attorneys Act pursuant to a power of attorney are known as substitute decision makers because they are tasked with making decisions and substitutions for the grantor. It's important to understand that there's a difference there. The attorneys are in place to make the decisions for the grantor and not to complete any task. So they don't have to go and run errands for the grantor. They don't have to work as a PSW. They can hire the service, but the decision of hiring that PSW to assist the person, for example, is a decision that the attorney for personal care will make. So now that we establish what a power of attorney is, I can move on to my next slide, in which we'll talk about choosing an attorney, right? So you don't have to name the same individual or the same individuals for these two types of documents. You can pick different people to act as your attorney for property and for personal care. Also, another very common point, people often think that they have to name someone as their attorney for property who is well versed in finances or accounting, but that's not the case. In my opinion, the most important thing is to name someone who you really trust, because that person will have full access to your assets, and sure thing, they should not go and use the assets, for example, for their own benefit. So they should not go into your bank account, take some money and use for their own benefit, but they will have that power, right? They will have full access to your bank accounts and to your finances. So this is a very important point, to name someone who you trust. Then there's also some people that you cannot name as your attorney for personal care. So you should not name, for example, your physician as your attorney for personal care, or someone who provides health care service to you for compensation. And you should also not name someone who provides residential social training or support services to you for compensation as your attorney for personal care. Then, if you decide to name more than one individual as your or person as your attorney, you have to decide if you want them to act jointly or jointly and severally. So jointly means that, let's say that there are two people that were named as your attorney for property. If it's jointly, they will have to make all of the decisions together. So they'll have to sign all the checks together to have effect. If it's jointly and severally, either one of them can make a decision on your behalf, on the behalf of the grantor, or, for example, sign a check, and that would be valid. There's no right or wrong here about picking jointly or jointly and severally, but you should take a look at whether the two people that you were naming as your attorney, they work well together or not. And while jointly and severally may seem quite practical, right? Either one can go ahead and make a decision on your behalf. It does leave also room for perhaps more complications. For example, if one of the attorneys go ahead and start making decisions, alone, and there's no really good communication with the other attorney, so that could be an issue in the future. So these are points to take into consideration when preparing these documents, and to have a frank discussion with the lawyer that you're going to work with. But as I said, there's no right or wrong. It's different for each individual and for each situation. Another important point when you're thinking about the person who you're going to name as your attorney is really relevant for the power of attorney for property is the residence of the attorney. So if that person is a resident of Canada, great. If it's not, if that person lives in another country, then there could be tax implications in doing that. So that individual who is now appointed as an attorney and that will start acting as attorney for property for the grantor may have, for example, to disclose the properties of the grantor when filing the attorney's own tax return. So that's one of the potential tax implications for some countries, but there could be many others. There are many different countries and they each have their own tax rules. So that's one point. Another point is, for example, if the attorney for property is someone who lives in the USA, then that person would have to work with an investor or financial advisor who is licensed to practice in Canada as well as in the US, so that financial advisor could give advice. Otherwise, they really cannot. So that's another practical implication, that it may be fine you may feel the grantor may feel comfortable with that, the attorney may feel comfortable with that, but are points that should be looked at and taken into consideration when preparing these documents.
So how to make a power of attorney? The first, best, most recommended option is to hire a lawyer that specializes in estate law, such as Mariana, to prepare these documents. You can also purchase power of attorney kits and find templates online. There's some available on the Ministry of the Attorney General's website as well. We do caution against this, though, as we have seen some cases where the validity of a power of attorney document is being challenged due to formalities not being met that are required by law, which many people would be unaware of. An example of a formality required is that a power of attorney document needs to be signed by the grantor, and this may seem obvious, but there's lots of instances that we see where a power of attorney document isn't actually signed by the grantor, it's signed by another individual on their behalf, or it's not signed at all. The power of attorney document also needs to be witnessed by two individuals in the presence of the grantor. And the witnesses of these documents cannot be the grantor's spouse or their children. So we have seen those instances as well. When a lawyer isn't involved in this process, these formality requirements can be missed and then result in the power of attorney document not being valid. And again, when a lawyer is not involved in the process, capacity issues of the grantor, any concerns, or undue influence of someone else influencing their mom or dad to make a power of attorney, that's also not being assessed by a lawyer. So that can give rise to litigation and is a very common issue that we see in our practice. So when do power of attorney documents come into effect? It's really dependent on the wording of the power of attorney document and the type. So I'm going to review three types, which include a general power of attorney for property, a continuing power of attorney for property, and a power of attorney for personal care. So the first, a general power of attorney for a property, that takes effect as soon as it is signed and witnessed, unless stated otherwise in the document. And it's in effect until the grantor becomes mentally incapable, at which time it would then become revoked. And this power of attorney can be beneficial because it can be limited. So it could be limited by task. So for the specific purpose of selling your home, it could be limited by type of property. If you don't want everything you own to be managed by your appointed attorney, you can limit the property that your power of attorney covers. So a common example that we see is excluding corporate assets. And last, it can be limited by time. So you could specify that it starts from a specific moment or at the time that it's executed or after a certain event happens. The second is the continuing power of attorney for property. So like a general power of attorney for property, it takes effect immediately unless stated otherwise in the document. But unlike a general power of attorney for property, it allows your attorney to continue acting on your behalf after you become mentally incapable of managing your own affairs. So I would say this is the most common of the two power of attorneys for property. And then the third is the power of attorney for personal care. This comes into effect when the grantor becomes incapable of making personal decisions for themselves. So your attorney is only stepping in when there is a personal care decision that you can't make yourself. And determining incapacity or whether you're incapable to make a decision, that's usually done by a healthcare professional. So it can be a doctor. Most often it's a capacity assessor, which would require an individual going to a capacity assessor and having an assessment completed, and they determined what your level of capacity is. And it can be fluid, so it's important to have that done. When a power of attorney document is no longer in effect. So there's three circumstances in which a power of attorney document will no longer be in effect. The first is if a more recent power of attorney has been executed by the grantor, that will then revoke the previous version. The second is if the document has been terminated by the grantor or declared invalid by the court. This could be due to not conforming with the signing formalities. It could be due to the individual not having capacity at the time that they executed it. And the third is when the grantor passes away. So this is important. The power of attorney document is only valid during the grantor's lifetime. So upon your death, your last will and testament, if you have one, then becomes an active document and is governing any of your property. And at that point, whoever you have named as your estate trustee, executors, they would then handle your estate administration. Leanne is now going to go over the importance of making these documents.
Thanks, Chloe. I cannot stress enough the importance of making a power of attorney document and having those in place. Now, in an ideal world, a power of attorney will never have to come into effect because none of us will find ourselves in a position where we cannot make a decision for ourselves. And in an ideal world, we will all maintain autonomy over our own affairs. However, the harsh reality is that many of us will get to a point in our lives where we're no longer able to make decisions on our own and will need assistance. Incapacity could strike at any moment. It could be a motor vehicle accident, for example, or it can creep steadily over time, such as cognitive decline and cognitive impairment or dementia. But when the time comes that you're no longer able to make decisions on your own, you're going to want to make sure that you've put in place measures to account for this possibility. And you're going to want to make sure that you choose the right person to manage those affairs. And then notably, if you don't make powers of attorney and you become incapable of managing your own affairs, there will be no person there who has the legal authority to make those decisions for you, except there is the exception of treatment decisions. And just to note, under the Healthcare Consent Act, there is a hierarchy of people who are authorized to make treatment decisions for you if you do not have a valid power of attorney in place. But it may not be a person who you want to be making those decisions for you, such as a child or a sibling. In addition, the personal care decisions are quite limited, and it's limited to only treatment decisions. So this doesn't have decisions on, let's say, your shelter or safety, which visitation falls under. And those items are not covered by the Healthcare Consent Act, just as an example. And then also, in the absence of a power of attorney, there's no similar piece of legislation that authorizes someone to make decisions for you with respect to property. And that can cause serious issues. And we'll address what happens in circumstances where you don't have powers of attorney in place and you become incapable of managing, let's say, your property and or personal care. And then I'll leave it to John next to talk about the consequences of not having powers of attorney in place.
Thanks, Leanne. So if a person does not have powers of attorney in place and that person becomes incapable, this has the propensity to cause major issues with financial institutions, with the Canada Revenue Agency, accountants, social assistance agencies, and real estate agents. And this is because there's no person who has legal authority to manage the incapable person's financial affairs. And until someone takes steps to obtain that legal authority to manage the incapable person's affairs, everything relating to the incapable person's property remains in limbo. This is one of the main consequences of not having powers of attorney in place. A common scenario that I deal with in my practice entails an elderly person becoming incapable of managing their affairs and incapable of living on their own and having to leave the home that they live in to take up residence in a long-term care facility. And because that person who now resides in the long-term care facility is incapable of managing their property, that person cannot take steps to sell the home that they no longer live in. The home just sits there. This is usually when an attorney for property would step in to list the incapable person's home for sale, proceed with the sale, collect the sale proceeds, and deposit those proceeds into the incapable person's bank account for their exclusive benefit. But when there's no power of attorney in place, there's no person who can take the steps to sell the property. Nothing can be done with the home until someone gains that legal authority to manage the incapable person's affairs. And this, as you might imagine, can have serious consequences for the incapable person if they need to access the equity in their home to afford the long-term care that they want and that they deserve. So if a person without powers of attorney becomes incapable, it is possible for a person to apply to the courts to be appointed as the incapable person's guardian. A court-appointed guardian is very similar to an attorney appointed pursuant to powers of attorney documents in terms of duties and obligations. A guardian and an attorney are both substitute decision makers tasked with making decisions on behalf of the incapable person. The main difference between guardianship and powers of attorney is that with guardianship, the court decides who an incapable person's substitute decision maker will be based on whoever applies to the court seeking this relief. So another consequence of not having powers of attorney in place is that someone could apply to court seeking to be appointed as your guardian who you never in a million years would entrust with making decisions on your behalf. This is more common than you might think. In contrast with powers of attorney, the grantor of a power of attorney chooses who will be their substitute decision maker if and when they become incapable. I trust everyone participating in this webinar this evening would prefer to choose who will be making decisions for you if you ever become incapable, as opposed to leaving it up to the court to make a decision, choosing from whoever has applied to become your guardian. And if no one applies to become your guardian, it's possible for an entity in Ontario known as the public guardian and trustee to be appointed as the incapable person's guardian. Another consequence of not having powers of attorney in place is a financial consequence of rectifying the issue. Getting powers of attorney drawn up can cost anywhere between $400 and $700. Obtaining guardianship costs upwards of $7,000 in legal fees. It usually takes a number of months to wind its way through the court. And if there are competing guardianship applications, for example, two adult children vying to become their incapable parents' guardians, the legal fees can absolutely skyrocket. So if you do not have powers of attorney in place, I strongly recommend that you speak with a lawyer sooner than later, as incapacity can strike at any moment. Now, moving away from the consequences of not having powers of attorney in place, Leanne is going to touch in on some of the duties and obligations of an attorney.
Attorneys for property and personal care are governed by a legislation entitled the Substitute Decisions Act. And under the Substitute Decisions Act, there are references throughout outlining the duties and obligations required of an attorney for property and an attorney for personal care. And it is helpful guideline to assist powers of attorneys or guardians who are going through this role and this process. And the Substitute Decisions Act can be found online, and it can be referenced, and it outlines again the duties and obligations there. But in particular, attorneys are required, first of all, to consult the incapable person and supportive family members in the management of the person's affairs. And this is mandated by the Substitute Decisions Act. So attorneys cannot, therefore, just go ahead and make all decisions without telling anyone or consulting anyone, and not keeping family members informed. And unfortunately, we do see this happen, and this can cause, understandably, a lot of conflict in families. And so it is very important if there are supportive family members, and also if the incapable person is able to provide some wishes regarding some decisions. It's important to consult and keep people involved and keep everyone on the same page, because that will decrease conflict. Importantly, an attorney for property can do anything with respect to the management of property, except they cannot make a will for an incapable person. And this makes sense. The power of attorney could create any will with any terms, and potentially could benefit the whole estate going to themselves. And obviously that's not appropriate. And that's why when wills have been executed by individuals that are capable, those will stand and they can't be changed by a power of attorney. And the same thing goes for beneficiary designations made on certain assets, such as tax-free savings accounts, RIFs, as well as the creation of joint bank accounts with right of survivorship. So these can be seen as testamentary decisions, because if, let's say, an attorney for property makes himself the beneficiary of those assets, they could be receiving significant assets on the death of the incapable person, and that's not appropriate, obviously. And then also the incapable person, while capable, to be able to make the decisions with respect to their assets, whether that's to an individual or to their estate. So those are notable distinctions on what a power of attorney for property cannot do. But generally, everything else, an attorney for property can make those management decisions for property on behalf of the incapable person. The duties of a power of attorney for property can include managing real property, as John was discussing earlier. So let's say there is a property and there's rent being collected on the real property, then that's a management decision that the attorney will have to make. Payment of ongoing expenses such as property taxes, utilities, payment of repairs or improvements that are required, landscaping that maybe requires snow removal, some of those kind of decisions, the attorney would be stepping in to act in the best interests of the incapable person. Attorney for property can also apply for benefits. They can also pay credit card debts, liabilities. They will compile and instruct information to be given to an accountant to prepare tax returns and dealing with all that. So there are significant duties and responsibilities. Now, with respect to a power of attorney for personal care, such decisions can be directing care decisions at a nursing home or assisting in the placement of an individual into a nursing home, directing healthcare professionals as needed, monitoring visitation access to ensure that all visitations are in the best interest of the incapable person, nutrition decisions if needed. So those are all duties and obligations of an attorney for personal care. And then a main duty of an attorney for property is the duty to keep proper accounts of all transactions within the incapable person's assets. So keeping track of transactions that are coming in, and then also transactions that are coming out. And the one thing that all of us within our practice areas that we see are accounting issues and powers of attorneys not keeping the required and necessary accounting and documentation of what's happened within the incapable person's funds that they're managing. And so in the duty account, again, this is one of the main issues that we see, and We're often called upon to assist in preparing accounting and bringing those accounts to the court, and in a process called a passing of accounts. And John's going to talk about this duty to account as well as the passing of accounts further in the next section.
Yeah, so as Leanne just pointed out, the duty to keep accounts is one of the primary duties of an attorney for property, and it is undoubtedly the source of most power of attorney related disputes. When an attorney is acting pursuant to a power of attorney for property, the attorney has unfettered access to the incapable person's bank accounts and investments. They can do anything with the incapable person's property that the incapable party would be able to do if they were still capable. Think investment decisions, withdrawing money, transferring money, writing checks, selling homes. When an attorney is handling someone else's money, the highest standards of honesty, integrity, and trust are demanded from that attorney. If the attorney does not act honestly and in the incapable person's best interests, the incapable party could suffer significant financial harm. And time again, we see scenarios where an attorney improperly depletes the incapable person's accounts for their own personal gain, leaving the incapable party penniless, which is why you should think long and hard about who you might want to fulfill this role for you if and when you become incapable. The legislation is clear that an attorney acting pursuant to a power of attorney has a duty to account to the grantor of the power of attorney if and when the grantor seeks an accounting. An attorney has no obligation to account to anyone other than the grantor of the power of attorney unless a court orders the attorney to provide an accounting. The best advice that an attorney for property can follow is to always be ready to account. And the attorney should assume that he or she will, at some point in the future, be required to provide an accounting and should conduct themselves accordingly throughout their tenure as attorney. So attorneys should keep a ledger of all money coming in and out of the grantor's accounts, should, on a monthly basis, do a reconciliation to make sure that each transaction depicted in the grantor's bank accounts can be accounted for with supporting documentation. In managing the incapable person's property, the attorney should be able to account for every penny spent on behalf of the grantor and every penny collected for the benefit of the grantor. So, for example, if an attorney accesses the grantor's bank account to purchase a $40 pair of reading glasses at Shoppers Drug Mart, the attorney should keep a receipt for those reading glasses to support the debit transaction depicted in the grantor's bank statements. This way, if the attorney is ever called upon to account and a question is raised about a debit transaction at the Shoppers Drug Mart on November 26, 2025 in the amount of $40, the attorney would present the receipt and advise that he or she purchased reading glasses for the incapable party. The unfortunate reality is that if an attorney is not able to account for a given transaction, a $40 expenditure at Shoppers Drug Mart, for example, it is open for the court to draw an adverse inference that this $40 transaction was not for the grantor's benefit and that the $40 purchase at Shoppers was a purchase made by the attorney for the attorney's own benefit. Now, we all make purchases on a daily basis for ourselves, sometimes numerous purchases per day using a credit card, debit card. We don't have to worry about keeping track of those purchases and providing an accounting to others because we're spending our own money. An attorney does not have this luxury when they are spending an incapable person's money. All the time, we deal with situations where an attorney did not maintain proper records. The attorney is called upon to account, and my office has to assist the attorney with piecing together an accounting that sometimes dates back many years, many hundreds, sometimes thousands of transactions, which is very difficult to do in the absence of receipts and invoices. So I'm going to move on to common issues that attorneys encounter. Being an attorney, and for anyone who's acting as an attorney, you may know already, being an attorney for a loved one is a significant and often a thankless undertaking. Even though the attorney voluntarily accepted the role and is doing their best to assist the grantor with their affairs and carrying out their role, attorneys can face criticism and allegations of wrongdoing. And the critics are usually family members who historically have not got along with the attorney, and they are now using this power of attorney relationship to make the attorney's life difficult. So common issues include a family member may demand an accounting, and upon being provided with an accounting or being denied the accounting, that family member will accuse the attorney of not maintaining proper records or of stealing from the incapable party. A family member might accuse the attorney of not properly managing the grantor's property or not ensuring that the grantor is receiving the health services they require. There might be an accusation that the attorney is personally benefiting from the grantor and that the benefits are improper. For example, consider the common scenario of an attorney living with the grantor, providing care to the grantor, but also having access to the grantor's vehicle, not having to pay rent or a mortgage or utilities or groceries or gas. To visit with the grantor in their home or in a long-term care facility. We also see a lot of issues with joint accounts, and I suspect we might have some questions about this once the presentation's done. Joint accounts are a major hot topic in the world of power of attorney litigation. It's common for an attorney to be a joint account holder with the grantor. And sometimes the attorney might even receive this advice from a bank representative that having a joint account with the grantor, with the incapable party, is a good idea, that it is convenient. I can assure you that you will never hear this advice from a lawyer. An attorney should avoid having a joint account with the grantor because it is a recipe for disaster, especially in circumstances where parties are already critical of the attorney and the attorney's conduct. If the money on deposit in a given account belongs to the grantor, to the incapable party, the attorney's name should not be associated with the account. The account should be in the grantor's name solely, and the attorney should access the account in their capacity as an attorney. The power of attorney document is given to the bank. It's lodged with the bank, confirming the attorney's authority to access the account, and the attorney accesses the account on an as-needed basis. So issues with joint accounts arise when the attorney treats the account as if it belongs to them, even though the money actually belongs to the grantor, to the incapable party. Another issue is the attorney may have creditors themselves. They may have found themselves in some financial predicaments, issues, and the creditors may try to garnish the account, even though the money doesn't really belong to the attorney. But to the creditor, they'll see this account and the money in it, because the attorney's name is on the account, in the mind of the creditor, well, that's the attorney's money too. And so we'll see situations where creditors will try to seize accounts when it really is not the attorney's property. Another issue when the grantor dies, and Leanne touched on this a moment ago, the attorney might take the position that because they were on the account jointly, that they become the sole owner of the account. And the banks will say that. The banks will say that if there's a joint account with right of survivorship, when one person dies, and quite often it's the elderly, incapable grantor, that the surviving party becomes the owner of the account. The law says the exact opposite. The law says that money actually results back and falls back into the grantor's estate to be distributed in accordance with the will. There is a significant amount of litigation on this very point. The very fact that an attorney's name is on an asset with the grantor will draw scrutiny, especially if there are critics. And especially if the attorney's name was added to the account around the time the grantor's capacity started to be an issue. So the takeaway here is that your name should not be on an account as a joint account holder if the money in the account does not belong to you. When faced with allegations of wrongdoing, there's usually a threat of litigation, including a threat by the aggrieved party that they will seek a court order removing an attorney. And Leanne's going to provide some insight on that right now.
So although financial elder abuse is obviously not present in all cases, we thought it would be beneficial to discuss today some of the red flags that we commonly see in cases where there has been discovery of there being misappropriation or inappropriate activity by an attorney for property. So some of these flags are restricting visitation access suddenly to the incapable person by the power of attorney for no apparent reason is commonly seen. A change in how the incapable person views other family members, and usually this can be seen as a sudden change in having negative opinions or views on a family member. So we've seen that, unfortunately. And again, for no apparent reason at all for the change in views. Powers of attorneys and last wills and testaments documents suddenly changing as well and excluding certain family members. And one or more family members benefiting significantly more than others, and that it's a significant change from previously known wishes when there was no concerns of there being any capacity concerns. Transfers of real property suddenly being completed from an incapable person, often a parent, to one child, excluding other child or children. And we are increasingly seeing litigation as a result of that. And usually this is under the guise of trying to avoid probate fees by having a property suddenly being held jointly between a parent and an adult child, because jointly held property will bypass the estate. So we've seen that sudden change. And then changes in spending habits, such as funds disappearing quickly from accounts. Some of the transactions clearly are not for the benefit of the incapable person. A decrease in the volume of assets, even though the incapable person's spending habits have not changed. An incapable person's spending habits or spending being unnecessarily restricted because they're being told that they don't have money to afford, let's say, a new pair of glasses, for example, but they do have funds, but they're being told different incorrect information. And then also the incapable person just not being aware of their funds and being provided incorrect information by the attorney. So these are not shown in every case, but we do see, unfortunately, these flags often in cases where there is a consideration of having an attorney for property removed. So if you come across this unfortunate scenario, and there are concerns of misappropriation of funds, you can go to the court and seek the relief of having the attorney for property and/or personal care being removed. But again, it is a high threshold to meet, so you have to have significant evidence to support the inappropriate activity. But if there is sufficient evidence that's presented to the court, and then the judge will make the decision as to um, whether the attorney for property should be removed. And then briefly, there is a two-part test that the court will consider on whether an attorney for property should be removed. And it's so one, there must be strong and compelling evidence of misconduct or neglect on the part of the attorney before the court will ignore the clear wishes of the incapable person, because prior to their incapacity, they did appoint this person and they wanted this person to manage their affairs. So there needs to be that strong, compelling evidence to go against those wishes. And then two, the second issue relates to whether the court is of the opinion that the best interests of the incapable person are being served currently by the attorney. So this test needs to be satisfied before the court will intervene. And Cloe is now going to outline some real life examples of when the court was considering this issue and what evidence the court relied on to have the attorney removed versus not. So I'll leave it to Chloe.
So a few cases we're going to look at. So the court's finding an attorney to be acting improperly. And if you're currently a power of attorney, listen closely because this is what not to do. And if you're currently thinking about making a power of attorney, these cases highlight the importance of who you pick as your power of attorney. So the first two cases highlight the importance of a power of attorney's duty to act in the grantor's best interest. So in the Burke estate case, here a husband was named as power of attorney for his wife, and during her lifetime, he used the power of attorney document improperly. So he transferred Canadian savings bonds that were registered solely in her name to their joint names, so that upon her passing, they would pass to him by right of survivorship. And he did this because he found his wife's will and found out that she wasn't going to leave him anything. So he was upset by that and took steps. And ultimately, the court held that the husband was in breach of his fiduciary duty that he owed to his wife, as he was not acting in her best interest, but rather for his own benefit. In a more recent decision, the Bellafield decision, the grantor named her daughter as power of attorney, and the grantor was later declared incapable of managing her property due to being diagnosed with dementia, Alzheimer's. And around the same time, the grantor's son discovered that his sister was essentially using their mom's money as her own, such as a personal ATM, is a common saying that we use when looking at these cases. So the daughter was buying new tires for her car, a stove, a freezer. She was paying for her personal legal fees for an unrelated dispute to her mother. She was commingling her mom's money with her own. The court removed her as power of attorney as she was clearly not acting in her mother's best interest, and it was essentially stealing money from her mother. And in this case, the court also pointed out that an attorney for property must always be in a position to prove the legitimacy of any disbursement, purchase, expense that is made on behalf of the incapable person. And this relates to a power of attorney's duty to account, which John discussed earlier, and the importance of keeping all receipts and records of purchases as a power of attorney. In another decision, White and White, here there was two children named as their mother's power of attorney, one of the attorneys brought an application to have the other removed as they were not able to agree on appropriate expenditures for their mom, such as the purchase of new clothing, and having someone come and read to her at her long-term care home. The court ultimately, in this situation, declined to remove one of the attorneys as the court wasn't satisfied that there was strong and compelling evidence of neglect or any misconduct. It was really just the fact that they were not getting along. But this case does highlight the importance of who you name as your power of attorney. You don't want to name your children who have a history of not getting along, your siblings who don't have a history of getting along, because it ultimately can result in litigation between these parties. And one last case in Carey and Carey. Here, there were two sons appointed as their mother's attorneys for property and for care, and they essentially moved their mom into their home with them and refused their remaining siblings to have contact with their mother. And they claim that this was on their mother's request. So these excluded siblings had concerns that they essentially had kidnapped their mother as a way to misappropriate her funds. And they were right in part. So the court did remove the two sons as attorneys for property as they had failed to account for several transactions in her bank accounts. But interestingly, here, they were not removed as attorneys for care. So even though they failed to foster this regular contact between their mother and the rest of their siblings, there was evidence that the mother was happy and healthy in their care and that she wanted to continue living with them. So this case again highlights the importance of who you choose as your power of attorney and is an example of when the court will try to respect your wishes as she clearly appointed them at a time when she was capable.
So, if any of you are acting in the capacity as an attorney for property, or you find yourself in this role in the future, here are a few practical tips to navigating issues that may arise. Take any concerns that are raised about your conduct, about what you're doing, you're not doing, take them seriously. There may or may not be legitimacy to the concerns. If you simply ignore the concerns without properly responding to them, you could find yourself in a costly legal battle that could have been avoided had you just responded to the concern in the first place. Next, seek legal advice to determine how best to respond to any complaint made against you and respond as best you can in a timely fashion. Too often, attorneys ignore complaints that easily could have been addressed in a timely fashion, resulting in litigation, again, that could have been avoided. When responding to complaints on your own, we recommend that you do so in writing, always. An email, a letter attached to an email, or sent via courier, registered mail, even a text message. All smart moves. This ensures that your words are not twisted, your response is documented, and there's the benefit more often than not of a timestamp on the letter, email, or text message that you send. If you or someone you know are ever named in a lawsuit relating to power of attorney issues, we do strongly recommend that you contact a lawyer immediately. These things can spin out of control. They can spin out of control quickly, and with a skilled lawyer, you should be able to keep things from spinning out of control too much. And always a good idea to seek legal advice. Okay, so switching gears and moving away from contentious issues relating to powers of attorney, Mariana is going to provide some information about the importance of estate planning.
Estate planning is the process of making arrangements for the management and transfer of a person's assets and properties after death and in case of mental incapacity. So you're going to look at how the assets should be distributed to the beneficiaries. Will ensure that your wishes are carried out, and you also have the opportunity to minimize tax. There are a few vehicles that we use, a few instruments that we can use to in the preparation of a estate plan. So we're going to prepare a will, powers of attorneys, trusts perhaps, and also look at the designation of beneficiaries in many products. And the way that I see estate planning is truly a gift to your family and friends and loved ones, because you are going to have a plan, right, of what you wanted to see happening to the best of your abilities, of course, during mental incapacity. If we're talking about powers of attorney, for example, so the documents that are used when you're still alive, and then upon your death, if we're talking about, for example, a will. And going to the next slide. So power of attorney, as I said, is one piece of estate planning. And the estate planning, it's much more comprehensive than that, right? And for me, these documents, so the will, the powers of attorney, and the designation of beneficiaries, they should be looked at all at the same time and together, because these documents will speak to each other. So for example, for power of attorney for property, when the attorney is going to start acting as an attorney for property, that person should be looking at the will of the grantor, so the person that they're going to help and make the decisions on behalf of, because there could be certain properties, for example, that are gifted to someone in a will. So the attorney for property should know that and should act accordingly. Right? They can't, for example, if mom has a power of attorney for property and a will, and now the attorney for property is going to step in to take care of mom, and mom now needs to go to a long-term care home, and her house, she used to live alone, now can be sold. The attorney for property should be looking at the will for mom to see whether the house was gifted to someone or not. Are the proceeds of sale for that house going to a specific beneficiary or not? And that's why power of attorneys, they're super important, but they are one piece of a comprehensive estate planning. Thank you. I think we're good. Yeah, to
Thank
move
you.
to the questions.
Well, thank you all very much. That's lots of information that you guys have provided. And the case examples are really interesting, kind of shows how it all fits together. Yeah, so we will open it up to questions. So I see some people are trying to raise their hand. We can't answer you verbally. You need to type your questions into the Q&A box at the bottom of your screen. So yeah, anyone with questions, please enter them in the Q&A, and some people have been doing that throughout the presentation, so we can start off with the questions that are already there. So the first question, is a power of attorney able to renounce as one? If so, what is required to do that? So I'm guessing that means, like, if you're named as power of attorney, are you able to renounce?
I can answer that one, Tara. So there's a distinction to be drawn between renouncing and resigning. So renouncing is what you would do before you even begin to act. Okay, so a person becomes incapable. You find out that you're named as the attorney. It should never be a surprise to an attorney that they are named as an attorney. A grantor should always speak with the attorneys before popping them into the document, just given how significant and serious the document is. But an attorney, for whatever reason, may or a named attorney might say, I have too much going on in my life. I don't want to deal with this. I'm starting to develop cognitive issues on my own. I can't take this on. There's no obligation to accept the position. So there's no formal way to renounce. What an attorney or a named attorney, the smart thing to do would be to put in writing that you do not want to accept the office as attorney, making sure that gets to the grantor or whoever advised you that the grantor is incapable, and making sure that also gets to the alternate named attorney in the document, in the power of attorney document, if there is one. So there's no formal way of doing it, but there's better ways of doing that, and putting it in writing is what you should do. Resignation, on the other hand, the legislation sets out what you're supposed to do. So just as I said before, you're going to put it in writing. You're going to, confirm to the grantor you're resigning. You're going to deliver that resignation letter to the grantor. You're going to deliver that resignation to the grantor's spouse. You're going to deliver that resignation document to the alternate named attorney, and a resigning attorney should always be ready, as I said earlier, to account, depending on how long that attorney's been acting in that capacity. It could be a year, it could be 5 years. That new person who steps into the role as attorney, they're going to want to make sure that they're picking something up clean, that there's not going to be a bunch of issues, and so you're always gonna want to put that resignation in writing. Always recommend that you seek legal advice before you resign, so that you do it the right way. Because unlike renunciation, resignation, there's a bit more to it, and there's wrong ways to do it, and we see quite often where there's some confusion about whether or not an attorney actually resigned, and the date on which their resignation takes effect.
Sonia, you're muted.
Thanks for that, John and Tara. Yes. The next question we have is just someone who's asking, when would be the best time to choose your power of attorney? And I'm wondering if there's a difference between power of attorney for health versus property, and when those things would then be put into play. Sure, I can answer this one. So the best time or when to choose a power of attorney would be now, ideally, because as stated previously, we don't know when incapacity could arise, unfortunately. We could be involved in a motor vehicle accident and lose capacity with an acquired brain injury, or it could be gradual over time with dementia, for example. So really, it is the best time to start planning now, and choosing that person, and then implementing that choice in executing power of attorney documents. So I think that process should start now. I can't speak for anyone else, but I know I've done that process already. So it's always important to start now. And then there are the two different roles, as you were mentioning, Sonia. So there's the power of attorney for property, and then a power of attorney for personal care. And the same person could be appointed as both, or it doesn't have to be. You could have different individuals in those roles, but again, you want to have someone or some persons that can work cooperatively, and that there won't be conflict between those two roles, because you do have to have individuals. If you're going to have two different individuals in those two roles, we want to make sure that they can work together, make decisions together, because there is a little bit of overlap sometimes, and you want to make sure that they're on the same page. And then I'm sorry, Sonia, what was the last piece that you had on the end? Yeah, another question.
Just around when those things would come into play, and it would be simply when the person has been deemed to no longer have capacity. So if you're having a power of attorney for property, does that mean they can access your account at any time, or do you have to prove evidence that you no longer have capacity to manage?
Yeah, it is a difficult determination on when that individual is no longer able to manage their affairs and when the power of attorney document comes into an effect. And it really depends on the actual document of the power of attorney. Sometimes a power of attorney may specify a capacity assessment being required, or a doctor's note being shown. I know sometimes there are some banks that are requiring a doctor's note now, before allowing the power of attorney to gain access and to have that management of the bank account. Um, but yeah, sometimes it is through an organic process though, between the incapable person and the attorney, where the incapable person realizes that they need assistance and they're asking for assistance through their attorney. And it is that organic process where that document is enacted. So it is a case by case basis, for when those documents would be enacted.
And one thing to add to what Leanne just said, and I think she was absolutely correct saying that now is the time to consider who your power of attorney is. But so too is after you get the POAs, the powers of attorney in place, to continue to look back at those documents as time goes on. Changes happen. You might have an attorney named in the document who becomes incapable of themselves or who dies. And we have situations where a person might have a valid power of attorney document in place, but by the time it needs to be activated, well, one of the named attorneys is deceased and the other one's incapable, and we're stuck with that scenario where we're running off to court to seek guardianship. And so always just keeping an eye on how things are going. And the same applies for your will too. You're going to want to update your will when there's major life events, there's births, there's deaths. You might want to look back at your power of attorney document if your named attorney becomes a bankrupt. Maybe you don't want that person managing your money, right? So it's a constant fluid thing where you're always going to want to be looking back at that document well capable so you can make changes to that document if necessary while you're still capable of doing so.
Great, thank you. Next question. So someone's describing a situation here. So my father went with my mother, who has dementia, to a lawyer to get a will and power of attorney, and the lawyer refused to make one for my mother because he thought she was not of sound mind. What do we do in this scenario? So I guess they thought she was not capable of making her will or power of attorney at that point.
Yeah, that's a tough one, Catherine, and we see it time and time again. And as best you can, try not to point the finger at the lawyer. Lawyers are kind of the gatekeeper when it comes to the creation of wills. If I don't draft wills anymore, Mariana does. But if someone comes into my office when I still drafted wills and I had concerns about capacity, it's inherently awkward to say I don't think you have capacity. But like what we recommend in those situations is there are experts out there, assessors who can assess a person's capacity to make a will. And if your loved one, Catherine, marches back to the lawyer's office and says, here, I have a capacity assessment. I've been found capable of making a will. That will act as an insurance policy of sorts for the lawyer, and they'll tuck that into their file. They'll make the will. The lawyer is always just concerned about a future lawsuit, being sued themselves, or just becoming a witness in a will challenge lawsuit. And so we're always on guard, more so now than ever, as we have these changing population dynamics, where lawyers are hesitant in situations where there may be capacity concerns to make that will, to make that power of attorney, to act on instructions that might not be in the person's best interest. But here with a will, I do recommend you can go see another lawyer, or you can get a capacity assessment, and you can take that capacity assessment back to that lawyer, or go to a lawyer of your choosing. But just to circle back, I wouldn't put too much. I wouldn't be too critical of that lawyer. That lawyer is probably just trying to do their job as best they can.
Thanks for that, John. That was great. Someone's just wondering if we're going to be sent copies of the slides. So I want to let everyone know that we are recording this. So for anyone who would like a recording of this, you can review the whole thing again. So we'll make sure we get anyone who requests that. And the next question is asking, what is your experience with POAs for property or personal care who live in different cities or different provinces?
I can address that question. So I I it really depends on the situation, right? Like if you are living in a city, let's say in Ontario, but you're able to travel if necessary, let's say to London, because that's where the person is that you are managing their property and personal care. If that's a possibility, then it can work quite well. If you're in a different province, it does pose challenges, let's say if you need to make immediate care decisions. I don't think it's a huge barrier. I will say that it is an issue though. If there is a big travel distance between you and the incapable person, if you have been jointly appointed with another person to be attorney for property or attorney for personal care, because those decisions need to be made jointly. So if there needs to be, let's say, a bank account open, both of you would need to be present. Or if there was a decision that needed to be made jointly together in the same spot, like again, you'd have to come down to, let's say, London in order to implement that decision. So yeah, it really depends on the situation, how much management there is for the property and personal care, your ability to travel. But I don't think it's a barrier at all. But it is a consideration just depending on your circumstances and your family members and their time and ability to travel. And so yeah, there's a few considerations, but not a huge barrier.
So this person says, I care for my disabled aunt. Is it appropriate to have a power of attorney for her? I have already been designated her decision maker by OCAH. I'm not really sure what that stands for.
Might be Ontario Health at Home, but
Oh, could be Ontario Health at Home.
Yeah, I can answer this one as well. So it is still appropriate to have a power of attorney. I'm not sure exactly what that acronym stands for, and what the duties or responsibilities of that role is, but definitely a power of attorney for property would be required to make decisions on property, such as if there was real property or bank accounts need to be opened or bills to be paid, liabilities to be paid, taxes to be filed. Like there still needs to have that authority to manage property. Personal care decisions, yes, like a power of attorney is still required to have that actual authority to make those decisions. The only thing that's kind of you're able to do without the power of attorney document is again treatment decisions under the Healthcare Consent Act. So that's what like legally for the authority, those documents are still necessary in order to do those management decisions.
And just to add to that, I mean, also, I mean, I don't know the extent, what the disability is or the extent of the disability, but regard should be had to, if she's still capable, that power of attorney document should be drawn up sooner than later. And if she's not capable, you really should be considering guardianship sooner than later. The sooner you get it, the sooner you're going to be able to assist with the management of her financial affairs and certain health decisions. So it's definitely something that there's no harm at all in getting that POA in place or getting guardianship in place.
Thank you for that. We have some thanks coming in, so thank you for sharing your time and expertise, saying it's very helpful. So just want to extend that to you. And the question is just asking what the outcomes of power of attorney cases are when it's problematic. So I know you discussed some of it, but I don't know if you want to highlight anything else that might be exceptional.
I can start us off. So number one, attorneys can be removed, which can then result in the grantor not having anyone named. And if they're incapable at that point, that can result in guardianship having to be brought, which results in further legal fees being incurred. That's a main consequence. The second is costs, legal fees. So, for example, we have several cases where powers of attorney use their parents' accounts as their personal ATM, and money's missing and needs to come from someone. So if there's evidence of misappropriation, then you can be personally responsible for paying back your parents' estate, or if they're alive, paying funds, plus legal fees. So I'd say costs is also a major consideration as well.
Thank you. Okay, question here. So once you use power of attorney, so for example, for your husband, does that person then lose their ability to make any legal decisions in the future?
It depends. So if it's a power of attorney for care, that should mean that he is already incapable if you're using it. If it's a power of attorney for property, no. So power of attorneys for property can be more fluid in that if it's a continuing power of attorney for property, you could go to the bank on your husband's behalf, of course, with his authority and instruction, and pay a bill, make a transaction, for example. But if it's not a continuing, then you shouldn't be doing that.
Thank you. Follow up from the person who was just discussing how they went to the lawyer and the lawyer said mother doesn't have capacity. What they're saying is that they actually do have a capacity assessment scheduled, but they do think that their mom would likely already not be able to make decisions for herself. So I think they're just wondering, so then what do we do now?
Yeah.
Do they have the right to pursue guardianship?
Yeah. So as Leanne mentioned earlier, an attorney can't make a will. A guardian cannot make a will. No harm in proceeding with this capacity assessment, and it has to be a capacity assessment with a designated capacity assessor, right? Not a doctor, not a geriatrician, an assessor who can actually assess whether or not someone has testamentary capacity. If the person's incapable of making a will, then they're incapable of making a will, and that door has closed, and they're stuck with their existing will. And if they don't have a will, then we're going to be dealing with Ontario's intestacy laws, which talk about what happens with the person's estate if they die without a will. Now, in terms of management of affairs right now during her lifetime, if she doesn't have powers of attorney in place, this assessor, in addition to doing an assessment regarding testamentary capacity, can also assess her ability to make powers of attorney, both types, and her ability to manage property and personal care. Quite often, what we'll see and what we do is we will send a person off if they want to make a new will or make new powers of attorney. We'll have the assessor assessed testamentary capacity, so capacity to make a will, capacity to grant and revoke both types of powers of attorney, capacity to manage property, capacity to make personal care. And the report generated from that assessment provides a lot of guidance in terms of what this person is capable or incapable of doing. Always a good idea to pursue and proceed with that capacity assessment.
Okay, another question here. So this says a husband and wife's accounts are all set up as joint accounts wherever it was possible. The house ownership is in both names, as well as additional properties. So it sounds like everything is joint for the couple. The bank accounts are set up with one signature required. Should this be changed for joint signatures when a power of attorney is trying to access the accounts?
I think, well, it's dependent on is the couple incapable of managing their property and that the power of attorney has been enacted. Because if the POA has been enacted and these individuals are not able to manage their property, their bank accounts, what we recommend is that a bank account be opened in trust for the incapable person, or I guess person. I haven't done that, a trust account, or haven't seen it where a trust account's open for a joint account. And I don't know if you can do that. But I think what would be set up as a bank account in trust for that individual that's no longer able to manage their property. And then the power of attorney has the authority to authorize transactions coming in and out of the account and be able to deal with it. That's the appropriate way being set to set that up. I'm not 100% sure if that answers that question, but I think legally that's what we would recommend.
And I know other years we've had the question because you talk about like not having joint accounts, but for a husband and wife who've had joint accounts for 40 years and everything's joint, and say the wife has dementia and so the husband is the POA, like is it okay for them to keep a joint account because they've always had that and for him to use that money, or should at that point should they be getting separate accounts, or what happens at that point?
That's a great question. I think given the nature of the couple, the joint account could remain, but I think there is still, just to be on the safe side, the attorney spouse needs to keep track of the transactions within the account, because when you are starting to deal with an individual that's incapable and not able to consent to certain transactions, I'm not saying this happens in every situation, but this could. A concerned family member could see certain transactions happening or certain items being bought that they think is not for the incapable person's best interests. There could be a conflict that arises, and then they will ask for the attorney to account. So if you maintain that joint account in that spousal relationship and it's joint funds, I would just say keep track of the transactions just in case, just to avoid any conflict or issues in the future.
In case it's questioned, yeah.
And sorry, if I may just add something a little bit from the estate planning perspective, probably good to also look, is there will like the whole picture and not just the power of attorney picture, because it may be the case that they always had this joint bank account, they're married spouses, and what they want is upon death to just flow to each other without having other legal consequences. So probably a good idea to look at the whole picture, I would say.
Great. Thank you.
Thank you. This question says, if you require legal advice as the power of attorney, who is financially responsible for the fees?
So at first instance, it is the attorney seeking the advice who is responsible for the fees. Now, what we'll see often, and usually there's not issues with this, because there's not issues with this. The attorney will access the grantor's bank account, take some money out of the grantor's bank account to pay the lawyer to provide the attorney with advice. The issue becomes when there's a fight between an attorney for property and someone accusing the attorney of doing something wrong. If the attorney starts using the grantor's bank account as their personal ATM machine to seek to pay for legal advice, we encounter major issues. I have a file like that right now on the go, where an attorney decided to help herself to some of the grantor's money to seek legal advice with respect to a dispute she's having with her siblings. And of course, we're trying to claw that money back into the estate of the grantor. The proper way to do it is the attorney personally incurs the fees, and then the attorney can get approval of their use of the grantor's money in the context of a formal accounting that goes before the court. And so that's kind of the belts and suspender way of dealing with these issues, is to not use the grantor's money for anything other than matters that are exclusively for the grantor's benefit. And I do appreciate that seeking legal advice on your duties as an attorney, may in a direct or indirect way benefit the grantor. But you could find yourself in situations, especially if you're using the grantor's money to kind of fund your own legal battle, your own legal dispute.
Right. Can your financial advisor be your power of attorney for property?
Short answer, yes. We have seen that. It's not common because, and I don't know if that many professionals want to take on that role because it is a big responsibility. Because it's not just managing investments as we've outlined, it's management of a variety of different types of property. So definitely you can have that conversation, but I don't know how willing professionals are willing to step in and be that to manage your property. So, but yeah, it's a possibility.
Great.
Okay. This question just says, how would you help the incapable person with their financial affairs without having a joint account?
You simply lodge the POA at the bank, right? That's why POA documents exist, and so you'll take in the original or a notarial copy of the power of attorney. You'll give it to the bank. You'll probably have to have some sort of meeting with the banks. Quite often, the banks will require you to sign some documentation confirming your status, your authority as an attorney for property, and then you can deal with their property. And an attorney never has to go on an account jointly with the grantor. It happens often, usually at the advice of someone at the bank who doesn't have to deal with the legal disputes on the backside. But you do not ever have to go on to the grantor's account. Leanne and I deal with this all the time in the context of a guardianship, where a person's appointed as the guardian for their incapable parent, incapable adult child. And the same question arises. The guardian says, I should be on joint. And unequivocally, the public guardian and trustee's position is your name should not be tied to property that doesn't belong to you, because it's at risk. Right. And so you lodge the POA with the bank. They know how to deal with it. And you can get an access card. You can gain control to online banking, and you can fulfill your duties and obligations as an attorney that way without having your name on the account as if it's yours.
Okay, so I know we're past 8:30, so a couple of questions. So we'll just get through what's on here and then we'll wrap up. But the next one is, if my mom doesn't have any property to be left and I only have power of attorney for personal care, would that be an issue in the future? And please give an example on how that can become an issue if there's no property left.
So if I'm reading that question, it sounds like this person could still is appointed as power of attorney for property and for personal care, but there may not be property to manage or property decisions to be made. If
No,
I'm
I
reading,
only have power of attorney for care, so I don't think they have a power of attorney for property. I think they only have personal care. So they're wondering, um, but they're saying there is no property to be left, which sounds like they mean after the person passes. So I'm not quite clear, but
um,
they
so
only,
yeah, I'm not quite certain of this
yeah.
question. Chloe, John, do you have any thoughts?
No, I mean, if so, so quite often you hear people say, I don't need to make a will, I don't have anything. And you might have a person saying, I don't need a power of attorney for property because there's nothing to be managed. Well, there's CPP, there's OAS. Randomly, people come into money. We see it all the time. And so, if mom in this situation is capable of making a power of attorney for property, she should. Just because there will be a situation potentially in the future where you're going to have to manage her financial affairs, and without that POA document or a guardianship order, you're not going to be able to do that. So if she's still capable, you can get one drawn up for relatively inexpensive if you do some shopping in London for a lawyer. But it could become an issue. To give you an example, it could become an issue if your mother ever receives some sort of benefit, and she wants to encroach on those monies, to buy her, a wheelchair or glasses or orthotics or anything like that, and you don't have that document in place, or you need to deal with the CRA, and the CRA will always say, well, who are you? What authority do you have to be calling on behalf of this person? Send us the power of attorney document. And so even if there's not a lot of property in a person's living estate, you'll still encounter potentially issues relating to the management of that person's financial affairs, with banks, with accountants, with the CRA, where it does make sense to get something in place if mom's still capable of getting that power of attorney drawn up.
And if there is no power of attorney for finances, because there's no automatic drop-down list like there is with the personal care. So if there's no power of attorney for finances, is it the public guardian and trustee that ends up being responsible?
Well, so there's a limbo. You're stuck in limbo. The PGT, the public guardian trustee, will take over if they are made aware that a person is incapable and they have property that needs to be managed. There's probably many people out in society right now who are incapable, who don't have an attorney and don't have a guardian, right? So the public guardian and trustee will step in. Quite often, though, they'll have to be, they can't go and search out every incapable person. So usually it has to come to their attention. Right. And it usually comes to their attention in the form of a complaint by a concerned relative, neighbor, or friend saying, I think this person's being financially abused, or I don't think this person's capable of managing their property, in which case the PGT has investigators. They'll send people out. And if they think it's appropriate and they think there's no power of attorney in place, they can become the statutory guardian for the incapable person.
Thank you, John.
So hopefully that answers the question.
This one is saying, my mother has dementia. She has limited funds to pay for her living expenses and is now dwindling her small savings account to buy from Amazon daily and racking up her credit cards. As her power of attorney, do I have permission to step in and take some control over her spending?
Well, I mean, if your mother's capable, so she may have onset dementia, but as we all know, dementia does not automatically equal incapacity, and so she could very well still be capable. And if she's still capable, she can make decisions that you might not agree with. If it were illegal to make bad decisions, I think we would all be locked up. right? And so if she has capacity, she can make decisions, she can manage her property as she wants. Probably because there is, early onset or onset dementia or some sort of mild cognitive impairment. It might be a good idea, and it's going to be a tough, awkward discussion with your mom, and most people don't like it when it's hinted at them that they might have a problem, they might have capacity issues, they might have dementia, and so it's you're going to have an intervention of sorts with your mother to basically express your concerns, and it might not go over well, at least at first instance. But there are options available to you if it doesn't go well. But I'd say first and foremost is potentially get mom to the doctors and see if the doctors will do some of those basic tests and see if the doctors will kind of elevate her diagnosis from mild cognitive impairment to early dementia to something more advanced like moderate dementia or just plain dementia. In which case you can gain control of her power of attorney. You can lodge it with the bank. You can cancel credit cards. You can put spending limits on debit. All of this, though, you have to approach in a very delicate way, because it's probably really going to upset your mother. And so my advice would be to seek advice from a lawyer on how to kind of navigate this in a gentle way that's not going to cause the relationship from being strained. And it's almost impossible to avoid strain in the relationship in these situations. But you got to do what's best for your mother. And that might be kind of controlling how she's spending her money, because if there's not a lot there and she has a whole lot of life left to live, she's going to need some money moving forward.
And then the last question, someone's just asking how much can legal fees be, like kind of what's the range? I think because you said you could get, I think, wills and power of attorneys done fairly reasonably. So what would be like a reasonable cost for getting that type of thing done?
I think Mariana, you may be the best person to speak to about this.
Right. It really depends on the needs of the person. For powers of attorney and wills, we have starting fees, but as I said, it depends what the person needs. So probably best to just contact the law firm and see how they work. What is their structure?
Yeah, tough one to answer. Great. And then a few people just, yes, excellent presentation, and thank you all very much.
Thank you.
So yes, it
Yeah,
was
thanks for
great
having us.
having all of you. Nice to get so many different perspectives and all of you involved. So yeah, we look forward to having you all come back again next year to give us some more
Yeah.
information. So
Yeah,
yeah,
no, thank you so much. Yeah, we
great,
really enjoy doing this.
wonderful. Thank you, and I hope everybody has a good night.
Great, thanks, you
Thank
too.
you.
Bye,
Thank you.
everyone.
I